Okay, let's dive right into this explainer. Back in 1999, there was this fascinating and honestly pretty complex constitutional court case that perfectly illustrates what happens when everyday workplace rights collide head-on with corporate transactions. Case CCT 44/03 reads almost like a legal tragedy. We're talking about a mini mall, a change of ownership, and one critical strategic error that ended up costing two workers their jobs. We are going to break down exactly what happened, why it happened, and the massive legal lesson hiding inside this whole dispute. It sounds like a simple question, right? But man, the answer can get incredibly complicated. Just picture this for a second. You go to work at the exact same physical location, doing the exact same job you've always done, but the name on the building's deed has changed overnight. So if your company is sold, who exactly is your boss? Is it the person who originally hired you or the person who just bought the property? This core mystery right here lays out the high stakes for two workers who fought for their livelihoods all the way to the highest court in the land, only to slam into an absolutely impossible reality. To understand how they got there, let's rewind and set the stage. The year is 1999 in South Africa. Our key players are two workers, Miss Ivy Kona and Mr. Lungile Busakwe. They worked at a mini mall owned by a company called Halgang Properties, CC. When a massive dispute blew up regarding their employment, they were represented by their trade union, the Western Cape Workers Association. Now, the central conflict revolves around these two workers fighting tooth and nail for reinstatement after being let go. But to really grasp the fallout, we need to see exactly how the dominoes fell. Here is how it all went down. The sequence of events kicked off in the summer of 1999 when Halgang Properties decided to sell its major asset, this mini mall, to a new buyer, Wembley Investments. The agreement to sell was struck on June 24th, but the actual legal handover, the day all the benefits and risks of ownership officially passed to Wembley, well, that was set for September 29th. Right in the middle of this transition, starting around August 17th, meetings began between the workers and a representative from the new buyer. The clock was absolutely ticking toward that September 29th transfer date, and the employment status of Ms. Kona and Mr. Busakwe urgently needed to be figured out. So during these August meetings, Wembley lays out a transition plan, and they actually made sure the communication was crystal clear. They even brought in an isisosa interpreter to assist, which was a good step. Wembley's proposal was basically this. The workers' contracts would transfer directly over to Wembley. All their past years of service under Halgan would be fully recognized. The exact same conditions of employment would apply. The only catch? A mere formality. For administrative purposes, they just need to sign new contracts with Wembley. On paper, from a corporate transition standpoint, this was intended to be a totally seamless handover of staff. Well, as negotiations continued, a massive impasse emerged. Wembley's offer evolved into a one-year contract. The workers, however, flatly rejected it. No way. Instead, they drew a hard line in the sand with two specific demands. First, a complete payout for their past years of service with Halgang. And second, they demanded to be kept in employment on an indefinite contract specifically by Halgang, the old employer. They absolutely did not want to shift to the new buyer. And this right here highlights a truly tragic misunderstanding. Halgang tried to explain to the workers that keeping them on was literally impossible because the whole business was being sold. Because of the deadlock, Halgang felt its only real option was to retrench, or lay off the workers for operational reasons. They even invited the workers and their union to make representations, essentially pleading with them to discuss ways to avoid the layoffs, or at least talk about severance. But the workers in the union completely refused to engage. Why? Because they were convinced that Halgang was, in their own words, still alive and kicking. They truly believed Halgang was fully operational and could just keep paying them. Which brings us to the breaking point. Facing a total deadlock, and with the official transfer of the mall looming just days away, Halgang made its move. On September 20, 1999, they sent a letter officially dismissing Ms. Kona and Mr. Busakwe for operational reasons, giving them 4 weeks written notice. To make matters worse, Halgang noted that because the workers had refused a perfectly viable offer of alternative employment from Wembley, they were no longer legally entitled to severance pay. Boom! A huge dispute immediately broke out, heading straight to the CCMA, the Commission for Conciliation, Mediation, and Arbitration, before inevitably spilling into the courts. This kicked off a massive judicial journey. It started in the labor court, where the workers actually won a surprising initial victory. The court ruled they had been unfairly dismissed and ordered Halgang to reinstate them. But that triumph was short-lived. Halgang appealed, and the Labor Appeal Court reversed the order entirely. Refusing to throw in the towel, the trade union took the fight to the absolute highest legal hurdle, applying for leave to appeal to the Constitutional Court of South Africa. Now, to understand why the workers lost on appeal, we have to look closely at Section 197 of the Labor Relations Act. Both the Labor Court and the Labor Appeal Court agreed on one crucial fact: the mini-mall was sold to Wembley as a going concern. That's a really vital legal term. It means the business passes to the new owner entirely intact, operational, and fully functional. It's not just selling an empty brick building, it's selling a living, breathing business. Legally, the transfer of a going concern fundamentally changes the reality of who actually has the power to employ workers at that specific location. So you end up with this totally surreal reality. The workers were essentially demanding jobs from a ghost. I mean, think about the timeline we just talked about. The business officially transferred on September 29th, but the union was seeking a legal order for Halgang to give the workers their jobs back after that date. Halgang didn't own the mini-mall anymore. They had sold it. Requesting Halgang to reinstate them was like asking a company with no mini-mall to somehow put them back to work inside a building it literally did not control. The entity they were trying to squeeze a job out of was functionally a ghost. And that brings us to the absolutely critical legal concept of this whole case. It's called want of joinder. I know, it sounds like some dense legal jargon, but stay with me because this is the big aha moment of our explainer. Joinder basically just means joining someone to a lawsuit. The workers' fatal strategic error was that they only sued Halgang. If they wanted a reinstatement order that would actually stick, an order that would let them walk back through the doors of that mini-mall and work, they absolutely had to include the new owner, Wembley, in the legal proceedings. Failing to invite Wembley to the lawsuit is a fatal flaw. That's want of joinder. The law is surprisingly pragmatic about this stuff. Under Section 193, subsection 2C of the Labor Relations Act, a court cannot order reinstatement if it is not reasonably practical for the employer to actually do it. Both the Labor Appeal Court and the Constitutional Court correctly recognized that ordering Halgang to reinstate the workers was physically and legally impossible. You simply cannot force an old employer to reinstate staff into a business they legally handed over to someone else weeks ago. It just doesn't work. And so, our legal autopsy concludes here. On November 14, 2003, the Constitutional Court handed down its unanimous judgment. The court noted that because the business had fully transferred to Wembley, the workers faced an insurmountable hurdle. Since they hadn't joined Wembley to the proceedings, they were essentially seeking a pointless order against Halgang. The Constitutional Court dismissed the application, determining the applicants simply had zero prospects of success. Because of that one fatal procedural error, the case was closed. There was no order for costs, but the workers' long battle for their jobs was officially over. It's a really tough story, but it leaves us with an incredibly practical takeaway. When a business transfers as a going concern, the legal reality of that workplace shifts overnight. The workers in this case were completely blinded by their conviction that their old employer was still alive and kicking. And that misunderstanding, combined with a failure to legally involve the new buyer, well, it cost them everything. So it leaves us with this final provocative thought. If your workplace changes hands, do you know exactly who is holding the keys? Because in the eyes of the law, demanding your rights from the wrong person is just as fatal as not demanding them at all. Thanks for joining me for this explainer. Keep questioning the structures around you.